Yo, folks! It is time to get into what will be the Carol Reed trial part 2. As I'm sure most of you already know. Last time, the first trial ended up in a hung jury. Reportedly, they were all agreed on not on the serious charge and were hung on another one. But the prosecution, the Commonwealth, decided we need to hire somebody from the outside. And so they did. They hired Mr. Brennan. And yeah, I mean, I understand why. I really, really do, because, oh my God, it was bad prosecution. Oh my God, it was a bad prosecution. Hello, love the duck shirt. Yeah, this will be my standard clothing covering the retrial, because I don't care which camp you're in, but if they put man hours and overtime into investigating yellow rubber ducks, yeah, I'm going to mock you. I am going to mock you. All right. Okay, let's see here. Hello, Anne on the Mouth, Christine, Gwendolyn, Swan Lake Lady, Showhost, Becky, Come Girl, Linz. Yes, I'm back from the cruise. I am back from the cruise. Ta-da! And Debbie, Brooklyn, Factual Lies, Cindy, Denise Els, and Patty. Something interesting about Mr. Brennan is that he really fought for or against police corruption. So it's interesting that he's handling this prosecution. Money. He has been hired for quite a decent amount of money. And I'm not holding that against him. I mean, even though he has previously fought against police corruption, he's still a lawyer. And if somebody wants to hire you, now, does this present an ethical dilemma for him personally? It might, but I can't take that into account, because this is about what on God's green earth, how are they supposed to handle the case next time around? What will be their tactics? And trying to find that out is, it's simply, I say, we need to check what went on in the hearings. So that is what is up now. We're going to start with the one where that took place a month ago. But I don't remember the actual date. Hold on. When was it? On November 26th. I believe that is the first with Mr. Brennan. KT says, I don't think attorney choose their cases based on principle. Well, not defense attorneys can choose to either take the case or not. Now, if you are mainly a defense attorney and then all of a sudden you choose to be a prosecutor, then yeah, it's a choice you made. I don't know why, and I must say, in the grand scheme of things, doesn't matter. He's there. He's there to perform a job. He's getting paid for the job. And it's 4 p.m. here, so I'm having a beer. Now, to make this interesting, let's see here. I've seen a lot of people do these goals, so yeah, I'm doing one as well. There. There. 10 super chats, $5 or more. I'm having a shot of whiskey. But, so yeah, this is not as much a stream about the evidence in itself. We know the evidence. We know the evidence by now. We know the witnesses that the prosecution brought forward and who they probably won't have the next time around. But in order to see predict what's going to happen, we need to take what do you call it? A helicopter perspective from the outside and see, can we determine what's going on by looking at how Mr. Brennan and his team is acting in court, in the hearings. Now, we also know that Judge Bev is biased. We already know this. We know about this really strange thing with getting people to just object, but no reason for the objection, which is really strange. And the sidebars, I really want to know what was said in the sidebars. If anybody has the transcript so I can get hold of the sidebars, I'm all for it. So let's just get into it with what happened in the hearing. Sorry, about a month ago. So let's see here. Or should I do this? No. Maybe this. No. Maybe this one. No. I'll take the standard one. Before I forget. God fortsättning. Or which translates into good continuance, or have a great life moving forward. It's hard to translate Swedish proverbs, but that's one of them. God fortsättning. All right, let's see. Second time around, it's very hard to win against the state. They fix their mistakes from first try. Generally, absolutely correct, Brooklyn. Generally, absolutely correct. That also depends on, because if you have the same set of witnesses, then you can fix stuff. Some of the witnesses for the state might not be around the second time around, at least not for the state. The sidebar transcript are sealed, impounded. That's stupid. Thank you, Mama Bug. All right, let's get on with it. I'm going to play this in 1.25. Let's get the subtitles up. 1.25. Let's see here. On color green. There.
There's 22-117 McConnell versus Karen Lee. Can I come to the microphone?
Thank you. Good morning, Your Honor. Hank Brennan, On behalf of the Commonwealth, along with me is Attorney Adam Lally and also Attorney Laura Cole.
Good morning, Mr. Brennan. Good morning, Mr. Valley. Good morning, Ms. Carter.
Good morning, Your Honor. Elizabeth Little appearing on behalf of defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears to be Zoom.
Okay, we can't see him now, Jim?
Yeah, we can't see you, is that okay?
All right, good morning, Mr. Jackson. All right, we have several motions this morning. Let's start with motion for admission pro hac vice that you filed. And Mr. Yannetti, I know these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Of this criminal nature, he has represented criminal defendants throughout his career.
Okay, all right, thank you.
Okay, so Judge Bev is a moron, as per usual, because that was clear as day what he was there for. Now, they used a little bit too much of a colorful language, but that's just the way it is. And Steve Keach takes us off with New Zealand, $5. Happy New Year, Nick. Happy New Year, Steve. Happy New Year.
All right, so let's go on to the discovery motions. We'll start with the requested records of Mr. Reed.
Okay. First, I need to. Now, you know me. I know about this case. I did not follow it. I saw some of the testimony. I saw some of the reactions from people I trust. But when it comes to watching the actual trial, I might have seen 10% of it. Maybe. The highlights, so to speak. Just so you know where I'm coming from. So I will walk into Karen Reed trial part 2, the retrial. More or less green in this. More or less green. And I do believe with the new set of prosecutors, they will try another tactic. I don't know which one yet, and that is why we are here, to take a helicopter perspective on how are they going to unfuck a clusterfuck.
Here you, Mr. Brennan.
That's an interesting folder.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed.
That's strange. But okay. I assume this is the prosecution wanting to show a pattern of Karen Reed not calling her parents. That's my assumption. Steve Keith, thank you for member for 6 whole months. Thank you. Thank you for sharing your precious time with us. Thank you for being here. Thank you so much for being here.
The Commonwealth has a burden with 2 of these charges, one being second-degree murder to show the element of knowledge. It is the government's burden to show that Ms. Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death.
Call logs, I don't think that shows anything of the sort unless they can show a certain pattern. And that as well can be easily be explained away. I mean, yeah, okay.
In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Ms. Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Ms. Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Ms. Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She called both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Ms. Reed knew she had done something terrible.
Don't they have Ms. Reed's phone? Okay, so if they have Ms. Reed's phone, that could be, I mean, okay, so they claim it's was on, first of all, a 40-something person calling their parents in the middle of the night. Is it usual? No. Do I call my dad in the middle of the night sometimes? Yeah. Mostly because he sent me a text, call me, and I don't see it until in the middle of the night, and I don't realize it's the middle of the night. And I mean, Miss Viking's kids knows they can call me at any point in time, and if they need me there, I'm going there. That's not. I think that's good parenting. Maybe Mr. Brennan didn't have good parents. I don't know. Or it's what I see in the chat here. It's a fishing expedition. I agree, because everything they need to know to establish a pattern is Karen Reed's phone, which they have.
She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is...
Now, his language here, I have to address this. He is talking as if she has already been guilty. But that is the standpoint of the state. That is the standpoint he has to argue. So, yeah. So that's nothing unusual.
To protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Ms. Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. No.
What? What do you mean, no? You have Ms. Reed's phone. You can subpoena her call records from her provider.
There were 2 search warrants on Ms. Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies.
Those are provided by the defense is not an argument. If you reference them, you need to provide them as well.
Search warrants on Ms. Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay,
And the other one is January 28th, 9:30 to January 29th, 5:30.
okay.
And so they're not in Ms. Reed's records. I am not looking to
Then write a damn subpoena for those other dates.
see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents for 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she was panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures.
So if anybody in that house had actually seen him, or the what's his face, the guy with the plowing, but how many was it? 5, 8, 10, 12 people who all left and nobody saw him. Oh yeah. But this is the this is the prosecution standpoint. They more or less, this happens all the time, folks. When the prosecution is moving to get more evidence, they only argue the things that they don't take in account what might speak against them. That is the defense job to bring that up. So he's arguing more or less that they're all somehow he's arguing that they can't get Miss Reed's phone records, which is bullshit. But he can still argue it and see where it goes. Thank you, Steve, for another 5 New Zealand dollars, getting us 20% on the way. Yes, I have one of these super chat calls. I have one of those up now. If 10 super chats within 45 minutes, and I'll take a shot of whiskey. And the end of this stream might get really, really interesting.
That could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell. Or they could have cracked his cranium. Now, certainly he would have suffered significant impairment. But I expect the government is pursuing a witness. And my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial.
So call him as well. If they plan to call him as a witness, they need his records for impeachment. But then again, they can do that with Karen Reed's phone. They don't need her phone or the mother's phones or the dad's phone.
The time of the phone calls to Ms. Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the yes in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny.
Phoenix, member for 10 months. Thank you so much. Jill Ems, is this a new lawyer? This is the new prosecutor in the Karen Reed case. His name is Brennan. He is usually a defense attorney. And hello, Jill, and thank you so much.
His daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting for her records. And so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed.
So he is looking for discrepancies between Ms. Reed's phone, Mr. Reed's phone, and Mrs. Reed's phone. But that's a stretch. If he already has Ms. Reed's phone, and he should have it. They have had it. I do recall she more or less turned it over immediately. But he presents a theory, but I don't hear any case law that supports this kind of action. So yeah, it sounds like a fishing expedition.
I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Okay, fishing expedition. But this is nothing new, folks. Prosecutors are always on a fishing expedition, almost always. With some exceptions, as in the Rex Hoyerman case, the Gilgo Beach serial killer, allegedly, where the prosecution have a bi-weekly meeting with the defense to hand over discovery. They have a strong case, they believe. This, as soon as we go into all of these fishing expeditions, here's a theory. Is it testing the judge on how much she will approve of more or less nonsense motions? That will tell him how far he can go in the next set of motions and in trial, possibly. So this might be him testing the waters. What do I get away with? It's a theory. Snibbles! Thank you so much for $10 with fishing poles. Fishing expeditions. Thank you so much. Thank you. Let's keep listening. Let's see what the defense has to say.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's
So even though he claimed he wasn't interested in a lot of these things, he still wants it. Okay, that's good to know.
seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't
Right.
prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's, and he wasn't present at the waterfall on January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night.
Ooh. Oh, hello, Mr. Jingles. Okay, so she has in the past denied the defense call records from people who were actually present at the crime scene and the bar. No, Mr. Jingles. Yes, hello. This is Mr. Jingles. He is our fearless leader in the Mr. Jingles Viking Thug Gang. Hello. Okay.
The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records.
Oh, okay. So they have in their possession Karen Reed's call logs. And the only phone call was after she found Mr. O'Keefe on the lawn. So where does this 1:30 call come from that the prosecution are claiming? What's the evidence of a 1:30 a.m. call to her dad? Is there anything, chat? Looking at you here. Anything that says there is a 1:30 phone call? Because if they don't have that, they don't have probable cause. And still, I mean, if there isn't one, then you can always argue what's the harm. But the harm is it's not necessary. It's a waste of time. Yes, hello, Mr. Jingles. You want some snacks? You want some snacks, Mr. Jingles? Yes. Oh. There you go. Here's some snacks. Here's some snacks. Where was I? Yeah, but what? It's a waste of time to give out if there is nothing there. If they don't have probable cause, then there's no probable cause, and it's a waste of time. American Dreamers, and no, her father looked at the twilight when they arrived at his house. Is that on video? American Dreamer says, well, they didn't call him as a witness, so usually parents are quite worthless as unless worthless as to testify against the children. It's more or less worthless unless you have something to impeach them with. Hey, GLMs, snacks from Mr. Jingles. I will make sure to stack up on snacks from Mr. Jingles. Oh, Mama Bug, she called her mom at 1:30 a.m., but it wasn't answered. She didn't call her dad until after they found John. Okay. So there was a phone call at 1:30 a.m. that went unanswered. Okay. Interesting. But they still didn't call her mother. Is there a deposition from the mother? As I said, I only watched maybe 10% of the first trial, but I do know none of her parents were called as witnesses by the prosecution. But also, as the judge points out, this is a new trial and with a new prosecution. Interesting.
It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards to the burden that they have to establish.
Thank you, Dave. $5 with a super sticker with hippos. Dave, are you calling me fat? Sneever says, don't worry, the other 90% was just Lally asking about the snow. Okay. I heard a lot about snow. As I said, I didn't watch much of this trial, of the first trial.
Established that the records are evidentiary and relevant. The Commonwealth, in its affidavit, set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his.
It's always a bad idea to give interviews to media. Always. Always. Because why, folks? Anything you say can be used, and will be used against you. Anything.
Phone records. And I would note the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, I believe I hit something, was the Chevy Traverse, which the court knows we have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed calls her father cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed."
Really? Parte said her lawyers let her do the interviews. That's a bad idea. Generally, it's a really, really bad idea. If you remember, when me and Dave covered the Jodi Arias trial last year, and her interviews, it's generally really, really bad to say anything at all. Let your lawyers talk for you. So yeah, I don't understand that decision.
Were made sometime after defendant struck the victim and before the victim was found. Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied.
Well, unless he is charged for aiding a criminal, then I don't see how they have a basis for this. But we also know Judge Bev have a habit of two sets of rules, one for the prosecution and one for the defense.
Thank you.
All right, thank you.
So again, this again might be Brennan testing the waters. How far am I allowed to go? All right.
Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
Don't trust a lawyer who says very brief.
In between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent that trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of the request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land crime. That alone is a basis to deny the request. And it's not permissive, it's mandatory that the court deny the request. Land crime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay, thank you.
I assume,
So we will move.
yeah, there will be nothing from the judge on this directly.
Move along now. Both
And I agree with the general consensus in the chat that no, the prosecution will not call the parents unless they have something specific to impeach the parents with. There's no use of calling her parents.
those are under advisement. We'll move along now to it's paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Corp. I do have an opposition that I received this morning and an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So,
Okay, this I've heard of. It is them, the prosecution wants everything and all, including notes of this interview. And initially, this is a First Amendment issue and goes under shield laws. Well, this particular Massachusetts does not have a shield law. It is under the discretion of the court, which I find insulting, that there are states in the United States that does not have shield laws. Tammy Fayette, are all the lawyers from the first trial still representing Karen from the second trial? Yes, and they actually made an addition of that. And I must say, I'm impressed because this defense of Karen Reed must cost her millions. But I also know that they have regular fundraisers for her defense. So, but still, it's a ton of money. And this also might be a tactic from the prosecution. Drain her assets. And I must say, you can agree or disagree with the methods of Aiden, Turtle Boy, but without his involvement and him bringing attention to this trial, to this case, she would probably be bankrupt by now. Probably be bankrupt. So, hey, been there, done that. Hey, yo, good to see you. All right, let's listen to.
did he file an appearance too?
Yes, previously.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
Carla Brikowski, as a congressman writing a bill for
Commonwealth
journalists.
filed a motion to reconsider in part, and in addition, there was a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after.
All right. Just for notice, I have one of these goals set up. 10 super chats for $5 or more, and I will take a shot of whiskey. Currently, there are 4 done. So if you want to completely see me trying to comment on this wasted, I need 6 more super chats, $5 each. But I will take into account the others because there's a few $2. So I will add everything together, but it needs to be done within 15 minutes. But no worries. I might take a shot of whiskey anyway, but it's fun to have that as a goal.
Review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
Thank you, Tammy.
And there were two
thank you for
different
being here.
interviews that were turned over. One was represented at the last hearing, that was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided.
Thank you.
And so,
Thank you so much.
there wasn't just a few redactions, they were significant. In addition, which is
I see this from Linz here. The defense didn't fight this at all. No, because it's not their fight at all. This is the reporter or the news agency. It's their fight to take. But it's a fight they have to take because she made an interview. And I will not give legal advice, but I think that was stupid of the defense to allow her to go into an interview because few bad choices and words, and it will be used against her. So no, I do not agree with Karen Reed's defense on that choice, that they allowed her to go on an interview.
notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson.
Carla Brikovsky, $10. Thank you. I want to see it, Nick. I hope you cover the hearings next week. I will. I definitely will. Unless it collides with the, well, I would still cover them, but maybe not live. It depends on what's up in the YSL case. But yeah, I definitely will. Brooklyn, $5, drink for 2025. Yeah, we are 2 out in the next, 2 more for $5 or more within the next 11 minutes.
33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change sometimes subtle, sometimes not so. There was a change
Nana
in
Misty is
the statement by
here.
Ms. Reed.
Thank you.
And so it is
you
clear
so much.
that there was an inference that in those redacted portions,
Happy New
there
Year
is
to you too, Nana
conversation
Misty.
or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss, but none of that is protected. None of that is protected. The defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies.
What can I say? Under these circumstances, with no shield law, he is correct. Which also makes this, I don't get it. Why did they allow her to go there on an interview? Gwendolyn asked, what was removed from the interview wasn't shown publicly. Does that make a difference? No, because if they discuss things with Ms. Reed in front of a reporter, it is in front of a third party, which removes the attorney-client privilege thing. So, and that is why I say that interview, stupid. Nana Misty gifted 5 memberships. Thank you so much. Thank you, thank you. Nana Misty is on a roll. Thank you so much. I need to start checking. Let's see here. I have. Hold on. New members today. 5. Honorary Viking. I believe that goes to Nana Misty. Misty. $20 plus 35. Who is the current honorary Viking? Current honorary Viking. Thank you so much. So yeah, we have. This is one of the things I have. You can, the person who monetarily supports the channel the most during the stream will be the honorary Viking of the stream. What is the goal? The goal is 10 super chats for $5 or more, and then I will take a shot of whiskey. And there's one more in 7 minutes, and then I'll simply restart it.
And there is no reporter privilege in Massachusetts. And so what has happened in this interview?
Sadly, they don't
that we
take
have
into
3
account
attorneys,
gifted memberships.
a defendant,
I
and a
agree.
reporter.
So we are
having a free
already
reign of interview,
reached
and
the
then
goal.
later deciding
So
what parts of the interview they want the public.
We already reached the goal, in my opinion. So if you're thinking about it, wait until we reset it, which is in 6 minutes or so. Oh. All right. And there we go. Nana Misty and Jill Ems. Thank you so much. And we goal achieved. And I will restart it. I will try to make a note that we are a bit ahead of that one. But let's see here. Where's my shot glass? There's my shot glass. Georgia, I don't think I have a Massachusetts one. I have Alabama. I have. Oh. I have Bucky's. I have Mississippi. Kentucky, Texas shot glass, and of course I have the Bigfoot shot glass. But I think, you know what, I'm going to take the Buckies. Tolamod you, and thank you so much, folks. Thank you so much. Dun, dun, dun. Cheers. Oh. Live long and prosper. Ooh. And thank you, guys. Thank you so much. All right, let's continue with this.
Public to hear what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law to protect statements that the defendant or the attorneys made that they don't want the Commonwealth to learn about is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all three of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those. The strongest way, the fairest way to pursue those with moderation is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it. She said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that never even may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in the case. And my empathy is to Ms. Voss, but to every other witness in this case, she's in no different position. It does not impede the progress of the Commonwealth.
That has absolutely nothing to do with your motion. Absolutely nothing. And for you who don't know, the yellow rubber ducky case, the judge threw it out. So this part is just wah, 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 playing on heartstrings.
It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it, and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions.
Hey, Penny. No, this is not. This part, what we're watching, is not new. This is from November 26. This is me preparing for the trial coverage of the Karen Reed trial part 2. I want to, via the hearings, listen to Mr. Brennan and form an opinion on, will there be a new tactics? And if there is, what might it be? But in order to do that, I must listen to it. I will read the motions. I will do that off stream. Because, I mean, how can they salvage all the clusterfuckery from trial part 1? So that is what I'm doing right now.
Confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. In the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Ms. Birch.
Thank you, Your Honor. Robert Birch, Court, Metro Court, and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion. And Your Honor, at that time, made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews.
I assume we are listening to the news agency's attorney now. If I were to do a US tour, I mean, I know the cost of my road trip from Houston up north, and it, with the airfare and the rental car and the gas and everything, if I'm supposed to do a month-long US tour, I think on travel alone, I spent $5,000 on travel alone. I would guess at least, if I'm going to do all of these meetups all across the United States. And it has to be at least 3 times that amount. So maybe I have no idea. Is that no? It can't be Johnny Depp, the Depp we heard tried kind of money for a Cada, because I mean he made, what was it, $1 million that year or something of the sort. So well, I wouldn't turn it down, folks. But no, I mean we are talking maybe in the 20 to 30K region. I will not hitchhike, Ben. They have done that. I will not hitchhike. Don't do a GoFundMe for me, folks. Do not do that.
They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back even at the first trial, to come back and request it upon review of the first?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay, go ahead.
Now, I'm not the kind of person to speak on somebody's look. Folks, the 1980s is long gone. It's long gone. So is the 70s hairstyle or the pole stash. Now, does he have the walrus kind of look? Yeah, and I'm not going to make fun of him for the lack of beard. I mean, I would imagine him and me are quite close in age. I have my massive beard and my long hair, and so, yeah, maybe I shouldn't talk too much, but I do believe this is more suited. That maybe not. I will not wear this to court. I will not wear Robert Ducky's suit to court. But then again, he is a corporate lawyer. He doesn't need to follow the trends. And he's making good arguments, and that is what should count.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family.
Let's see. Thank you to Tammy. Rubber Ducky, you're the one. Only before he gave Nick his shot. Thank you, Tammy. Now I saw something up here. Dun, dun, dun. Have I traveled anywhere lately just to say hi? Well, not in that sense. Me and Miss Viking took a New Year's cruise. And it got windy. It got really windy. Let's see if I still have it here somewhere. Dun, dun, dun. Hold on, where is it? Where is it? Dun, dun, dun. Let me show you. Hold on. Dun, dun, dun. This is the weather we went on a cruise in. It was windy. It was bumpy. It was wavy. And so, yeah, once we reached our destination, because the ship had to go for anchor, and so we actually asked, will you allow people to go to port? And after some discussion, they chose to go to port. So yeah, so we spent, well, New Year's on the ship, and the morning we went to port, and then we stayed in a hotel. So and this morning we drove back instead, because the weather was not improving. So yeah, we had a great time because we weren't affected as much, but they closed down so much on the ship, so we couldn't really do much of the cruising things. So yeah, but we had a great time. We had a great time. Let's go back to this.
And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. You said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seems to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corporation's counsel undertook time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss, the one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are the phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview. If forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case that has already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial, because if she is called as a witness, she is not permitted to sit in the courtroom for the proceedings.
So she did attend the last trial, right?
She did,
On a
because she was
daily
not on the
basis?
witness list.
Right, on a daily basis?
I believe so, yes.
Okay,
Every day? Yes.
okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry,
That was Ms. Voss who just responded to you, yes, correct?
yes.
Oh, so she's there now. Okay.
And finally, the Commonwealth asks for the first time for texts between Ms. Reed and Ms. Voss. And we do have texts. They are, the manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can try to guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask her we're willing to turn those over. They were not off the record, but I asked her we'd be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay,
And that's all I have.
all right.
I mean, he makes good arguments. Problem here is Massachusetts doesn't have shield laws. And with that, it's the judge's discretion. I saw the question in the chat here. When is the trial 2.0 supposed to start? Well, both the prosecution and the defense wants a trial start of April 1st, but the judge only gave them a general continuance, a general stay. So I don't know. It should have started January 27th, but now it will be later. That's all I can say.
Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
I have a copy of it.
Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph, the paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
Oh, look, there's the person who provably, while drunk, plowed into another person and almost ended that person's life. Who Miss Reed bailed out. So yeah, For those who don't know, this is John O'Keefe's brother. And he's a pile of human garbage. And I say that because he probably is a drunk driver who almost killed a person. No accountability. He even got help from Miss Reed. And now he does everything in his power to make Miss Reed look as bad as possible. Convenient.
This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging omissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews, the story changes. At one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the common.
AT has he not seen the house? I must. Let's see here. This is the house, right? You have the garage entrance, you have one entrance there, and then you have the front entrance. I don't know what they mean. Yeah, side door is located. Yeah, technically it is in front of the house. So it's not a side door in that aspect. It might not be the main entrance. So it's just a play of words here. So it's a play of words from the prosecution. So yeah, those 3 entrances are all in the front.
Position that is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made, 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Ms. Voss's interview, as I mentioned, there's statements, redaction, return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion.
Hey, good citizen became a member. Thank you so much. And for you who wonder, it's $3 a month and you get tons of members only content on my channel and your own emojis here on YouTube. Here they are. These are the different emojis. Let me just present them to you there, which you can choose. You have the Viking ones, you have the Boomer ones, you have my tractor, you have the 3-hole wonder. Mr. Jingles and Mr. Jingles Christmas. So thank you so much. Thank you so much. And I will count that in as well. We are 8 away and we have half an hour. That's the YouTube goal in the chat that you see. So we have 8 left, $5 or more. Sadly, they don't count memberships into that. But I think we're almost there. Technically.
Really has no relevance to the analysis. It's not on point. The reason I said it was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 of the affidavit. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to the 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the
folks. Should I start one of these like Baker and Mo have? The post-it notes? Maybe I should. I don't have no idea where to put them though. I need a board of. Will you? Mr. Jingles, will you hold on to the post-it notes? Oh, look at that toe beans. Good. Oh, you're having a good time, Mr. Jingles. You're having a good time. Yeah, go back to sleep. Viking ship post-it note. I'll look into it.
Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. And representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, and Ms. Voss, could decide to use that material. It wasn't that it was precluded.
This is why it's a bad idea to have interviews. Because the prosecution, especially in a state with no shield law, will use it. So yeah, that was a bad idea.
No one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it. None.
All right, thank you. So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add?
Yeah.
Okay. All right, so that is taken under advisement. Now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance on all 3 or arguing all 3. But so Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all 3. But do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the 3? There are 3 motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue? Okay. If you change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25, it's paper number 400.
Okay, I don't know, is the rest of this just media? Let's see here. Is the rest of this just media? Oh, they have something here in the end. Because media, yeah, I mean, it's not much they can do because they allowed her to go on an interview. And with several meetings with media, and there is no shield law. So let's...
There's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The
Still have the motion to continue under advisement. I need to see how we progress for that.
Okay. So the media wants, yeah, interesting. But yeah, it's not much the defense can do about that. I'm more interested in hearing this new prosecutor, how he argues these different motions against Ms. Reed specifically.
The Commonwealth's notice regarding the testing of the telematics system, where do we stand with that? Mr. Brennan? I know you had said you told them that, Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to...
Is that the expert who don't know the difference between bit and byte? Oh. Yeah, I heard of that one. That's stupid.
Texas on December 2nd.
Okay.
On December 2nd, they're
the
going
defense
to
can use
test
against
all
him.
of
You don't
chips,
even
and
know the
there's an
difference
SD
between
card that
byte
we expect
and
has
bit.
information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called a chip on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car because there's different software which will give it even a more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promised to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you.
That's really fast.
And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this, the transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor, I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had to go to the family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a week after the November 13th date. Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the court's specific question about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going to file a response to the discovery of communications in possession, custody, and control of the Commonwealth by 11/27, right?
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll
Okay.
file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with, expended many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there's a protective order, I can turn over the first production that I produced, and there is more to come.
All right, any
What is
objection to
this?
the protective order? I have not seen this document, obviously, nor the proposed order.
Right, there are a couple of issues related to this motion in addition to the protective order that I'd like to address with the court that I've briefly discussed with Mrs. Brennan.
I haven't read this yet, so I won't know what you're talking about, Mr. Bennett.
So I believe you have read our motion, right? The motion that
I
we.
read your motion, I haven't.
Right, so it's just in relation to the motion. Judge.
All right.
So, Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here, or was there a proposed protective order?
What is this
I have it right
protective
here,
order?
Your Honor. Mr. Brennan printed this to us this morning.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with?
There's no
defense team?
objection to the parties who would like to share with, and I understand it's without prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used a personal email address to make an ex parte communication with the court. One concern that we have is that...
Oh, no, okay. Is this part of the Morrissey using his personal email and personal phone to make ex parte communications with the court? Is this the thing they are talking about? Help me out here, chat. Factualizes? Yes. Okay. In my personal opinion, in your capacity as an elected official, it doesn't matter what device you use, what email you use, what smoke signals you use. Hand it over. Hand it over. First of all, ex parte communications, as far as I know, in the entirety of the United States, are frowned upon. They are presumed damaging for the prosecution. Presumed. That is why any and all ex parte communications must be communicated by the court itself to the defense. Unless they erased it. And it's not a civil case. In civil cases, the destruction of communications, which can be construed as evidence, are almost exclusively used against the party who commits it. They are presumed damaging enough. Yeah.
We were told this morning that with regard to Mr. Morrissey's text messages, not emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days. That obviously...
Say what now? If that happened here, that would be a criminal offense. You are not allowed to delete anything as an elected official. It's considered a criminal offense over here. I don't know if it's considered like that in the United States. I have to check that out. But yeah, what the actual F? That tells me that Mr. Morrissey is morally corrupt. If he uses his personal devices for ex parte communications with court and witnesses, allegedly, you over here on my side of the pond, fired, because we don't elect our officials. But any elected official over here that uses personal devices and then deletes it, thank you, goodbye. Go on. If a prosecutor were to use their personal device in order to try to have communications, since they are hired over here, not elected, hired, and a criminal investigation takes place. You should have that over there in the United States as well. I don't know if you have it, but yeah, this is bad.
Raises some questions for us, maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I
They
believe.
were preserved, Mr. Brennan?
I've been preserving since I started the task last week. I'll continue to preserve it.
All right, so that,
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan ordered conducted or conducted.
Say that you don't elect officials. Yeah, we elect our officials. We do not elect our prosecutors or our judges.
Himself, he had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
Well, the significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name, but we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court.
Well, knowing Judge Bev, or knowing of Judge Bev, that would implicate her. And I don't think so. But it's good that he brings this up in open court, because then it can't be ignored, at least.
Where this case originated, and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication. And we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan, and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the Daubert hearing.
That's fair enough. Thank you.
Does that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate complaints in the most broadest fashion. And I'll continue to do that. If they want to discuss how I can accommodate them, I'll do my best.
Okay. All right. So we will see everyone December 12th. So when do you expect to get me any written material you want me to have prior to the Daubert hearing?
Yeah.
Yes.
Your Honor, we've got the landing and hearing motion. I need to.
Oh, Daubert hearing, that's with the dog bite lady. The lady who is actually an expert in more or less everything.
Do it like it to you by the end of the week.
That's great. I expect to be here at the end of the week, so that's great.
Thank you.
And your response by next week, Mr. Yannetti? Ms. Little?
Yes, if we could have at least a week, Your Honor.
Okay, so I'll give you 10 days,
Thank you.
as long as that gets me before the 12th.
No problem.
All right.
Yes, Your Honor.
Yeah, if I can get it, as soon as you can get it. All right. Anything else? Yes.
I'm sorry to interrupt.
That's okay.
May I inquire if the executive order is going to be signed by the.
Are you going to sign the protective order, Mr. Yannetti?
I will, without prejudice.
I have the materials, I'll just wait.
Okay. All right, so if you sign it, then I'll endorse it, Mr. Yannetti. You had it, right? Ms. Little gave it to us just
I
now?
believe it was the office report.
Yes. All right, so this is the one that needs to be signed and I'll endorse it. Do you want to take a look at it?
Yes.
Okay, that. Oh, I don't.
I know you, and I will.
Okay, so that was that. That is really interesting. That is really interesting. Now, the reason why we are gathered here today. What do I believe Mr. Brennan's tactic is? With just this hearing, it's hard for me to make a conclusive opinion. Looking at his fishing expedition here, I get the notion that he is testing his limits. How far can I go with this judge? Now, I saw earlier about him not watching the first trial, and I mean, he's a lawyer. Most lawyers don't watch trials, but have he read the transcripts? Yeah, parts of them, I believe. Definitely, in order for him to make motions, he needs to have read the previous ones. And so the fishing expedition regarding her parents, she might, I don't know if she approved them or not. I mean, this is almost a month and a half ago. I don't think it leads anywhere, but it shows him how far he can go. And in order to get information via the judge. So if she approved of this, then he knows, okay, this, I can go this far. And then you still have what we brought up earlier, the thing about costs. Every time they are forcing Miss Reed and her lawyers to the court, I mean, in court today, 3 lawyers for roughly an hour and a half in court. Then you have the preparation, and then you have what happens afterwards. So say a 4-hour minimum today for attorneys that are at least $600 an hour, plus travel and stuff. So yeah, every time in court, 6 times 18, 1,800 times 4. I mean, it's 4,000, say, rough estimate. Every time they have to appear in court, it's $4,000. Every time. And now they might have another one brought in. Then you can take, Lynn says $6,000. Thank you. I don't do math good. So yeah, every time. And then we know they had a Daubert hearing, which we will go into maybe I will go into that on Monday. Then you have Daubert hearing number 2. So yeah, just 3 hearings, $25,000 easily. So yeah, tactics here seems to be from the prosecution. Try to get more information and drain her account. That is what I can say, my rough estimate now, listening to Mr. Brennan. I heard a lot about people believing he is he acted bad. I must say I kind of disagree. I think he's very calculated here. I heard him made some misstatement and misspellings. We all do. But yeah, so I do fishing expeditions in order for him to get more information, because he knows the first trial was a clusterfuck. And Lindsay says it's his demeanor. Yeah, don't mistake his demeanor in the hearings with how he will act in court. Two completely different things. Because here he only has to answer to the judge. In court, he has to think about the jury. And if he is a decent to good attorney, now is the time he doesn't care about how he is portrayed to us or to the defense. How much does he get away with the judge? And I can almost bet money his demeanor will change drastically once in trial. So that is my estimation as of now. And now, what I do believe he did not calculate is the generosity of the free Karen crowd. Now, I heard a lot about the supposed drama that's going on. I couldn't care less if you paid me. Does it create drama? Yeah. I will avoid that as much as I can. I will try to have this helicopter perspective here. What do I believe the tactics will be? Now, from this one hearing, it's hard to say. There will be more hearings. There will be the Daubert hearings. There will be more, which allows me to elaborate more. But for now, it seems like how much of a fishing expedition can he get from the judge and drain Karen Reed's funds. Now, I don't believe Karen Reed's funds will be drained. I heard what was the last crowdfunding for her? Let's see here. Justice for Karen Reed Legal Fund. Oh, almost $600,000. Yeah. But it's a $2 million goal. Yeah, I know. But $600,000 gets you a long way, especially if she's acquitted. And yeah, it gets her a lot. And she sold her house, didn't she? That gives her additional funds. She was not a poor woman before this, but they are trying to drain her funds. And that's the thing with the government. They more or less has unlimited funds, so they can do that. But that is what I had for you today, folks. Now, I see that the goal wasn't reached in the next set of super chats. I don't care. And as Tammy Butcher says, we ain't got no quit. Yeah. So cheers, folks. I hope you enjoyed. Give the thumbs up. Subscribe if you haven't. Share. If you have social media, tell your friends. And I will see you in the next stream, which will be tomorrow. It is Legal Vice's memorial stream. Tomorrow, I believe, at 8 p.m. Eastern Standard Time. We will hold a memorial stream for Jeff Legal Vices. And hopefully we can get some funds so Jeff's kid can get some help with getting his dad back to the United States and with funeral costs and stuff. So thank you again. Thank you for allowing me to do this. Thank you for the monetary support. Thank you for the moral support. And so just thank you. Thank you. And remember, folks, hug your family. Well, unless your family's crap, then screw them and give your love to the people who deserve it. Okay? Let's see, what can I send you off with? With Mr. Jingle's Christmas. See you tomorrow, folks. Thank you. Bye-bye.
In a snowy land where the dragons once roamed, a Viking and a cat make a cheerful home. Mr. Jingle purrs as he hangs the lights so bright. Together they bring warmth through a frosty night. Garlands wrapped around the many wood beams, Viking runs all tunes while Mr. Jingle dreams.